There are two reasons that I'm going to go through this particular slideshow with you, and they both have to do with your future assignments. One assignment you'll be doing in a group, and you were assigned a particular principle, one of the principles from the Individuals with Disabilities Education Improvement Act, one of the 6 principles that have been in the law since the beginning of our federal special education laws, the Education for All Handicapped Children Act. So they're the same. We know that there's zero reject, free and appropriate public education, least restrictive environment, non-discriminatory evaluation, parental rights or due process, safeguards, and parental participation. So you've been assigned one of those, and in your group you will be finding one particular case to present in a synchronous classroom. And I've tried to model for you in this particular PowerPoint what exactly you should include. You should include certainly who's involved in the case, the plaintiffs and the defendants. You should be presenting on some background information and the issue. What is the issue that is being decided before the hearing officer and our judges, if it goes to the Supreme Court level. And then what was the final order? So you're going to need to present that. Your next assignment is your final research project, and that is an assignment where you have to look at multiple cases over a period of time. So you should pretty much go back to the beginning cases of our laws, maybe right before the 1974-75 laws and regulations that we know were the first for children with disabilities, up through the present. You're allowed to select any particular principle that you'd like, and you're going to summarize these laws in terms of, again, background information, issues to be heard that were heard, decisions that were rendered, and the final orders as well. Many of these cases have gone through multiple reviews, so they can be quite lengthy and complicated. I'm going to be summarizing briefly, and the principle that I chose to summarize on is FAPE. So let me begin. So one of the very first, very, very important cases actually that resulted in a settlement agreement was the Park case. And we're very proud of that in Pennsylvania because we pretty much set the standard and set the for special education law. We gave the language and we identified the principles that would become part of the Education for All Handicapped Children Act. And the background information in this case was brought on behalf it was a class action, meaning that a number of children were identified, but it was brought on behalf of all children within that particular group. So at the time, children were referred to as having mental retardation. This was brought on behalf of all children within the state who were within that particular group. And so the issue before the judge was, can children with mental retardation benefit from an education? So again, I think I gave it away in telling you that it was a settlement agreement in 1972. And the order was that, yes, in fact, all children are entitled to a free public education. And even though we don't see appropriate per se, we do see in the order that that education must meet the child's individual needs. And another part of the order was that they started to really consider children with disabilities in terms of discipline. The children cannot be suspended for more than 2 days without a hearing. Another famous case was the Mills case, and this also involved FAPE. This was also brought on behalf of children being the plaintiffs and against a board of education, in this particular board of education being the District of Columbia. Now, the interesting thing about this case is that, again, it resulted in a class action suit. A number of children, though the initiating children were children with behavioral disorders. And the parents, what is noteworthy too, that is always identified in this case, were parents of the global majority. And these parents and these families were also noted as living in poverty, so that there wasn't necessarily any choice involved in terms of, paying for school at that point. And so the issue before the judge was that, did the Board of Education of the District of Columbia fail to provide a free, appropriate education to children with behavior disorders? What do you think? And the order pretty much was in line with the Park settlement, in that they were ordered to provide FAPE for over 18,000, about 18,000 children who were being either suspended, exempt from public education in the District of Columbia, certainly not offered an appropriate education in Washington, D.C. This particular case I was not familiar with, but I thought I would put it in there for two reasons. One is that you're going to research some cases and they're not going to be familiar to you. Some of them are very familiar because they're in all special education textbooks. Others are not. But the reason I chose this is certainly it involves FAPE, and it also is a Sixth Circuit level court decision. So it's a very high level court decision. So we know that by law or regulation, the parents must exhaust all administrative remedies first. So they have to go to due process first. And then before it would reach a high-level court, it will go through a state court. So these cases can take years. They can be very complicated. They also must go through a number of decisions before we get to a final decision. We know that the circuit courts are right under the Supreme Court, so they're high-level courts. And usually they are the final decision makers in terms of children and the special education system. So this was 1998, so you see that the first cases I selected were early on, and I went to about a middle ground one. So this involved a very young child who, by the time the parents filed for due process, the child was in the special education system, had multiple IEPs. It did involve issues related to the parents pulling the child out of school and unilaterally placing the child. So, going essentially against the multidisciplinary team, making their decision in terms of unilaterally placing the child outside of the system. It also involved an evaluation, a question of evaluation around whether or not the child had been evaluated appropriately to meet particularly the child's needs in the area of the child's learning disability. And so the issue before the Sixth Circuit Court was, did the pending IEP meet the child's needs for FAPE? What do you think? So in this particular case, the decision, in writing the decision, the judge said, yeah, the school did ignore red flags, that they did not evaluate appropriately and thus did not offer an appropriate IEP. The child that was placed in the private school, now they're saying that that school was appropriate and the parents are entitled to reimbursement. So the parents were entitled to reimbursement because essentially what the judge said is that the placement they chose was appropriate and that the school district at the time was not able to offer an appropriate program. This is another case that I was not overly familiar with. Again, a high-level case. I chose it partly because of the date as well, 1998. And this involved a child within the Second Circuit. So this is a situation where it involved a child with a pretty significant level of disability. And the district was going to certainly offer a year-round program in a specialized school for children with developmental disabilities. The parents felt that this particular day program would not meet the child's needs, and thus the child should be educated in a residential placement. They challenge such things as the size and composition of the proposed class that the district proposed in this day program, and then essentially went to due process. So this independent administrative review means due process. So the question obviously is the proposed placement appropriate to offer this child a free and appropriate public education? So for this particular ruling, the judge ruled in favor of the district and said that yes, this day program can meet the needs of this particular child. And so this was a decision that really involved two principles, LRE and FAPE, as well. And I point this out as well. I think that was another reason why I chose this case as I was reviewing it, because it's interesting to me that a lot of these principles um, are heard uh, in particular court cases. And so you'll have multiple principles being addressed and decided. And when you do your final paper, you're going to see the same thing as well. This is one of the most famous cases involving free and appropriate public education, and this again is in many, many textbooks. And I pulled this particularly because we're now moving up in terms of courts, and this is, we know from the US here, this was a Supreme Court decision involving a child named Amy. And we've heard about this particular court case, because it really helped us to look at a child with a specific disability. Amy was deaf, and she also was the product of two deaf parents. And the school district did initially really try to work with her around a total communication approach, which was what the parents were using at home as well. And but after a 2-week trial of an interpreter decided that those particular types of services were not needed. And so essentially Amy's IEP was put forward without a sign language interpreter. So again, is Amy's IEP appropriate to meet her needs? Is she being provided with an appropriate public education? What are your thoughts? So what this case is famous for too is, the language that came out of it. And essentially the language was that as long as the child is receiving passing marks and moving from grade to grade, then the child is receiving educational benefit. And that becomes really important throughout court cases, the ruling on FAPE, because what we're really looking at overall is there benefit? Is the child passing? This case is also famous because of the language that the judge wrote, in that we don't have to offer the child a Cadillac. We have to, essentially offer the Toyota, something I drive. This also is a very, very famous case, particularly within our circuit. It was ruled in New Jersey. It is a Third Circuit case, and it involves a child, TR. Now you're going to see a number of sets of initials. The child's initials are NR, but you're going to see two parents' initials as well. And I don't know their particular situation. Perhaps they were divorced or just, I'm not sure, but that doesn't matter. What matters is that the child was started in kindergarten and was recommended to be in a regular kindergarten program. And the parents at that particular time rejected that proposed placement and planned to send their child to a different preschool for one more year. And at the time, the particular township or the district did not offer a regular preschool program for non-disabled children. Rather, the township offered a single half-day preschool class composed of half disabled children and half non-disabled children. So this really involves, certainly you can see, issues of LRE. And so the parents wanted to place the child at at a learning center referred to as Rainbow Rascals. And this was the big issue here is that this was a private daycare center. The child had previously attended it. However, it wasn't approved by the state. So the question involves money as well. So, did the parents want to send their child to an approved placement for children with disabilities? And essentially what they wanted is they wanted tuition for this program, and they wanted to make sure that there was this supplemental special education service provided. So this case is important because it really looks at, again, FAPE in relation to LRE, meaningful benefit and continuum of placements. And so the issue before the judge was, should the district be required to pay for an unregulated preschool? What are your thoughts? Essentially, what was ruled is that the Board of Education was not responsible. But, sometimes in a decision as well, judges will say things that, even though the Board of Education was not responsible, essentially what they were saying is that, Rainbow Rascals was pretty much appropriate, and that they felt that this child could be educated in a wholly integrated environment. So sometimes the law is one thing, but the judges make clear that at this particular time, this would have been an appropriate placement. And the final case I'm going to address is a very recent Supreme Court decision case, Andrew versus Douglas County. It was decided in December of 2017. And again, becomes a very famous case, particularly because of its level, the Supreme Court level. This involved a young child with autism. And this child had, numerous IEPs from preschool through 4th grade. And by the time the child was in 4th grade, pretty much the parents said, there's just not really any benefit here. His progress has really stalled. And, the district continued to propose an IEP for the next year. But the parents said, he's not making any progress. And they unilaterally placed him in a specialized private school where he did make a lot of progress. So, really the districts, for a lot of reasons, will try to bring the child back into the district. And that's essentially what occurred. And the parents said, your plan is really no more adequate than what you previously presented. And they sought reimbursement for Andrew's private school. This went as high as the 10th Circuit, so again, went through due process, went through federal district court, went through the 10th Circuit. What became the issue before the Supreme Court is, what is the level of educational benefit school districts must confer on children with disabilities to provide them with a free and appropriate public education? So here we have that educational benefit coming up again, just like it did in Raleigh. And Raleigh said, just minimal, just passing. So what are your thoughts? So pretty much, actually I might have had the wrong date. I thought it was December, saying March here. But in any event, in 2017, we have the decision being rendered. And again, they don't really, parents and parents' attorneys saw this as really a win. School district attorneys saw this as a win case because they really don't offer us any guidance in terms of how much benefit, but they said it has to be more than minimal. So it has to be, you have to be able to prove really strongly that the child is benefited. And so I'm going to leave it on this slide to say that if I was to summarize this in research, some of the things that I would address in my summary is that when FAPE began, in terms of the courts and decisions, whether it be decisions by hearing officers, state level federal courts, or circuit courts, or the Supreme Court even, that we were really looking at issues of exclusion. and so bringing children into public education. But over the years, it's certainly evolved. And one thing that we are continuing to address, obviously, is the notion of appropriate. What is appropriate? And my guess is we will be continuing to address that as time goes on. And that concludes my research on cases and my short summary on the involvement of FAPE.